President, I have sought recognition to introduce a sense of the Senate resolution urging the Supreme Court to permit live television coverage of its open proceedings. This is different from previous legislation which I have introduced, which would require the court to permit live television coverage, and I offer this amendment on behalf of Senator Cornyn, Senator Kaufman, Senator Feingold, Senator Durbin, Senator Klobuchar, Senator Whitehouse, and Senator Schumer. The previous bills, which would have required the Supreme Court to open its proceedings to live television coverage, were voted out in the Judiciary Committee in the 109th Congress by a vote of 12-6, and in the 110th Congress by a vote of 11-8. And the basis for the legislative action is on the recognized authority of Congress to establish administrative matters for the court. For example, the Congress determines how many justices there will be, 9. The Congress determines how many justices are required for a quorum, 6. The Congress determines that the court will begin its operation on the first day of October. The Congress has set time limits. The shift in the resolution for urging the court is to take a milder approach to avoid a confrontation and to avoid a possible constitutional clash on the separation of powers. There's no doubt that the court would have the last word if the Congress required live television coverage, and as I say, there are analogous administrative matters which the Congress does control, but as a first step, today the resolution would urge the court to open its proceedings for live television coverage. And the thrust of this resolution is that the court should be televised, just as the Senate is televised, just as the House is televised, to familiarize the American people with what the court does. The average person knows very little about what the court does. The Supreme Court itself has held that newspapers have a right to be in a courtroom. Well, in an electronic age, television, radio ought to have the same standing. And the importance of the court is seen in the scope of the cases which they decide and the kinds of cases which they do not decide. For example, the court makes a determination on life, a woman's right to choose, makes determinations on the application of the death penalty, determinations on civil rights, on Guantanamo, on wireless wiretapping, on congressional authority, on executive authority. And the court is the final word since 1803 in the case of Marbury versus Madison, when the court decided that the court would be the final word. And that was the statement of Chief Justice Marshall, and it has stood up during the life of our country. And I believe it is a sound judgment for the courts to have the final word, for the Supreme Court to have the final word. But if the framers were to rewrite the Constitution, I think that the court would now be Article I, instead of the Congress being Article I and the executive branch, the President, being Article II. It is also important to note what the court does not decide. The court declined to hear the terrorist surveillance program. That warrantless wiretap program was found unconstitutional by the federal court in Detroit. It was reversed by the Court of Appeals for the Sixth Circuit on standing ground with a very vigorous and better reasoned dissent. Standing is a very flexible doctrine and usually made when the court simply doesn't want to take up the issue. But the terrorist surveillance program presented the sharpest conflict, perhaps the sharpest conflict between congressional authority under Article 1 with the Foreign Intelligence Surveillance Act establishing the exclusive way to conduct wiretaps and the President's Article 2 powers as Commander-in-Chief to conduct warrantless wiretaps. The Supreme Court denied to hear the case of the survivors of victims of 9/11 against Saudi Arabia, even though the congressional mandate is clear that sovereign immunity does not apply to foreign governments. Just in the past few years, the Supreme Court has decided cases of enormous importance. A few illustrate the proposition. The court refused to decide, the court did decide cutting-edge issues on whether local school districts may fulfill the promise of Brown versus Board of Education by taking voluntary remedial steps to maintain integrated schools, whether public universities may consider race when evaluating applicants for admission in order to ensure diversity within their student bodies, whether citizens have a constitutional right to own guns, whether states may exercise the power of eminent domain to take a personal residence in order to make room for a commercial development. The court has also declined to hear cases involving splits, that is, differences of judgment between different courts of appeals. It is not an effective administration of the judicial system if the case may be decided differently depending on whether a person litigates in the First Circuit or in the 11th Circuit. And then the district courts where the circuit is not ruled speculate as to what the Court of Appeals would have decided. We had a confirmation hearing yesterday with Judge Vanasky of the Middle District of Pennsylvania, and I asked him if you've seen situations where there are circuit splits but your circuit hasn't decided, and how do you handle that case? And Judge Vanasky pointed out that that was very problemsome. There are major matters where the Supreme Court has left these circuit splits standing. For example, whether jurors may consult the Bible during their deliberations in a criminal case, or whether a civil lawsuit must be dismissed predicated on state secret, whether the spouse of a United States citizen remains eligible for an immigration visa after the citizen dies, whether an employee who alleges that he or she was unlawfully discriminated against may claim benefits or exercise other rights under an employer-sponsored health care or pension plan, or when does a collective bargaining agreement confer on retirees the right to lifetime health care benefits? May a federal court toll the statute of limitations in a suit brought under the Federal Tort Claims Act? These are illustrative of very important decisions which the Supreme Court does not decide. Now, Congress can't tell the Supreme Court what to decide, but Congress may mandate the court's jurisdiction. But if this were in the public view, if the court were accountable for not handling such cases, I think the court might well take a different view. And it is not as if the court is too busy to hear these cases. Take a brief survey of the court docket. In 1886, there were 1,396 cases on the Supreme Court docket. It decided 451. In 1926, there were 223 signed opinions. So it's down from 451 in 1886 to 223 in 1926. And then by 1987, it was down to 146. And in 2007, the court heard argument in only 75 cases and issued only 67 signed opinions. So it is perfectly clear that the court's docket, with the four clerks which each one of the Supreme Court justices has, could well accommodate a more vigorous backlog. In the written statement, which I will include when I finish these extemporaneous remarks, I have cited quite a few cases where the court in modern times has not followed well-established precedents. Well, they have the authority to overrule their own precedents. It is something that the public ought to have an idea on and an understanding. I think that this is a particularly good time for the court to consider televising itself under the resolution urging them to be televised, since Justice Souter recently left the court. Justice Souter made the famous statement that if the Supreme Court was to be televised, the cameras would roll in over his dead body. And the members of the Supreme Court are very concerned about what their fellows think. And it may well be that in light of a strenuous objection by Justice Souter when he was on the court, that would have tipped the scales. But listen to what the justices have had to say on the issue of televising the Supreme Court. And I've made it a practice to question the nominees for the Supreme Court to get their views on television. Justice Paul Stevens said, literally hundreds of people have stood in line for hours in order to attend oral argument only to be denied admission because the courtroom was filled. And the practice is, if you can get in at all, you stay for 3 minutes, and then you're ushered out to let other people in because it's a small chamber. Justice John Paul Stevens said, television in the court is worth a try. Justice Ruth Bader Ginsburg said, quote, I don't see any problem with having proceedings televised. I think it would be good for the public. Justice Breyer said, at a time when he was Chief Judge of the First Circuit, quote, I voted in the Judicial Conference in favor of experimenting with television in the courtroom. And the Judicial Conference, making an analysis of television, made a favorable recommendation. And some circuit courts and some lower courts have been televised. Justice Sotomayor, in her recent confirmation hearing, said, referring to her experience with cameras in the courtroom, that the experience has, quote, generally been positive. And I would certainly recount that, referring to her colleagues on the Supreme Court. Justice Alito said that in the Third Circuit there was a debate, and he argued that we should do it, that is, televising, and said I would keep an open mind on the subject with respect to the Supreme Court. And the fact is that the justices frequently appear on television on their own. For example, Chief Justice Roberts and Justice Stevens appeared on interviews on ABC's Prime Time, Justice Ginsburg on CBS News, Justice Breyer on Fox News Sunday, Justices Scalia and Thomas on CBS's 60 Minutes, and all of the justices appeared for interviews that C-SPAN recently aired on its Supreme Court week. Public opinion polls are strongly in favor of having the Supreme Court televised. There have been numerous editorials in support, and recently the Supreme Court of the United Kingdom opened its proceedings for television. That is a very brief statement of a more expansive statement which I have prepared, and I think that the reasons for opening the court are overwhelming. In a democratic society, there should be transparency at all levels of government. The judicial independence of the Supreme Court is is of vital importance to be maintained, and they have life tenure. But there is no reason why the American people should not understand what they are doing. And the American people should understand that when they take a case like Bush versus Gore, where there is a challenge on the counting of the votes in Florida, and when Justice Scalia says there would be irreparable harm in allowing the votes in Florida to be counted because it might undermine the legitimacy of the new administration, the American people ought to have maximum access to understand what the court is doing. The American people ought to have maximum access to know that the Supreme Court of the United States declined to hear the decision on whether the president had authority to conduct warrantless wiretaps. The American people ought to know that all of these circuit splits remain unresolved at a time when the workload and the agenda and the docket of the Supreme Court has declined enormously. Mr. President, I ask consent that a dear colleague letter signed by Senator Cornyn and myself be included in the congressional record at this point.
Without objection, so ordered.
I ask unanimous consent that an extensive floor statement be included in the record, and that the congressional record contain my introduction of the floor statement. Frequently, when the floor statement occurs right after the oral extemporaneous comments, the reader may wonder why the speaker is repeating himself on so many of the same points. So I would like to have a full text as to what I'm saying now appear in the congressional record so that it is understandable why the long text appears after so much of what has already been said.
Is there objection?
Thank the chair and yield the floor.